Oh, will you sod off? Sorry, these pop-ups keep coming back. Click photo booth to resume. Piss off. Wankers. I can't stop reading it. I swore I wouldn't do this tonight. I've had a letter from the IOPC, the Independent Office of Police Conduct. Used to be the IPCC. Okay, it's comedy fucking gold, it really is. Press pause, go and stick the kettle on. You know the rest. They've decided not to uphold my complaint. I don't know if you can see this because it's quite dark and the writing will be backwards, but you can see that's in block type, big black type. Not to uphold. No, because they're telling me to fuck off. Fuck off, minion. We're not talking to you. Not only is it full of lies, but they contradict. If you watch IOPC Comedy Gold, which I did last week, so I've no idea what I'm going to call this one, they actually contradict themselves several times. I've never figured this out. They use a right posh bit of paper for the first page, which is really thick, and the rest of the letter is on thinner, sort of like Tesco type paper. I did actually get a signature on this one. Not a name, but S. Williams, perhaps? I don't know. But it was more than that I got on the last one. So they've done a bit about their legal responsibilities or duties. Which, as we've discussed previously, apparently they have none, because there's no need for any of that reasonable doubt stuff. They work on a different level. So it's basically, they've just kept repeating themselves, bloody dross, balance of probabilities. So calling me a liar, basically. Allegation 1. Mr. Dacus is alleging that Cambridgeshire police have tampered with court evidence. In your original complaint, you allege that Cambridge Constabulary tampered with the recording of a telephone conversation between you and PC Harmon. I understand that this recording was later presented in court as evidence of your alleged refusal to attend a voluntary interview. Well, that's funny, because in your last letter you told me I didn't have to attend a voluntary interview. Absolutely not. No way. And now you've gone back to... Do you want to go to a voluntary interview? No. Okay, we're arresting you for not attending a voluntary interview, sort of thing. So they've just contradicted themselves there. I mean, they're trying fucking hard. They really are trying. They are actually trying, very trying. You also state you wish to report PC Harmon. That could be Harmer or DC Harmon or PC Harmer. Could be any one of them, really. For lying, and following on from this, you point out your appeal representations. You do not know how it was determined you refused to attend a voluntary interview when the recording of your voice was almost completely inaudible. Bear that one in mind. I am aware the allegation of lying has already been the subject of a previous investigation and appeal. As a result, it is not within my remit. Yes, you just said the evidence hadn't been tampered with and that was the end of it. And as we know, we're not allowed to question police evidence at all. PC Harmon stated nothing has been tampered with. We covered that before. This is the best bit. This had gone through my mind, actually. This had crossed my mind. A copy was burned onto disk and forwarded to the forensic imaging department to prepare copies for the prosecution and defence. Now think about that, because there's only supposed to be 2 copies. The working copy, which the police have, and the one I get when I request the evidence. I'll repeat that, shall I? The copy was burned onto disk and forwarded to the forensic imaging department. How did that happen then? There's now 3 copies. And this is what crossed my mind before, because if you tamper with evidence in the form of this DVD disc and then you burn it onto another disc, that tampering is therefore undetectable, because all you're looking at is a copy of the original. Know what I mean? So I'm just trying to get a light here, guys. Did I have sight of the visual evidence and forensic imaging work? Yeah, well, if you've had sight of a dubbed copy, it's not much good, isn't it? They go through a lot of shit about what the image actually, which unfortunately I can't get these images onto YouTube, because otherwise you could all see what I'm talking about. The IO states that is his investigating officer, that is, his opinion that your copy of the footage is the same recording as the one that is held on the 2-serve system, because both versions have sections that are inaudible. Well, how could you tell if there were inaudible sections whether it was the same version? Oh, it gets better. From my analysis of the evidence, your copy of the footage was created from the version that is held on the police computer system. Yes, it was created. Have just admitted that they're fucking tampering with evidence. Do you know what I mean? And I have viewed document that shows the copies for the prosecution and defence were processed. Yes, they were. Created and then processed by the forensic imaging department. As a result, and this is brilliant, because they keep going back to this, these 3 words, in my opinion. Evidence is fucking inconsequential anymore, guys, as far as the police are concerned. It's in their opinion now. Facts? Ah, fuck it. Chuck facts in the fuck it bucket. It cannot follow that the copies were subsequently produced have been tampered with. So I'm just going to get rid of this little pop-up thing. No. No copies are an exact copy. I mean, you know, they're all fucking inaudible, so how can you fucking tell what's on them? But they're an exact copy. It is for this reason that I do not consider it proportionate to direct a re-investigation to interview all of the individuals that handled the exhibit, as indicated in your appeal, as I am not satisfied it was significantly altered the outcome. No, well, that's mainly because you don't want it to alter the outcome. Oh. It's fucking shocking, it really is. In light of the fact the original source of the exhibit was the same recording, whereby your speech was largely inaudible. Oh. This is a good bit. It is my view that P.C. Harmon's account made as the officer that is the subject of the allegation does suggest that she herself denies tampering with evidence. Well, that's all right then. As long as she denies it. Oh, look, there's a big rock covering up loads of corruption. Yeah, it's denied it. Let's not bother turning it over. It is my opinion that the presence of inaudible sections of recording does not automatically mean that the only possible explanation is that the recording has been subjected to tampering. No, but you're not looking at any other possible explanations, are you, really, love? Love? Oh, God, I've got to stop this. S. Williams, or whoever the fuck you are. No printed name, you notice. They've got as far as a sort of illegible signature. Now. There's no evidence to suggest that P.C. Harmon may have altered the recording. Well, no, she said she didn't, so that's all right. Fucking hell. I explained at the start of this letter I have to decide whether the evidence suggests that it was more likely than not that an alleged event or behaviour occurred. This could be as close as 51% in favour of one version of events. They're really fucking pushing this, aren't they? Let's try and convince them that the evidence didn't fall in his favour. We'll put 51%. There's an idea. Ultimately, it is unclear as to why the original recording of the telephone conversation was inaudible on your sections. And don't forget, when they told me they weren't going to court and then they did, this is what the judge decided on. All this inaudible evidence. I bet his name is either Judge Enright or Judge Chowdhury. I'm going for one of those two. Ultimately, it is unclear as to why the original recording of the telephone conversation was inaudible. The fact the subsequent copy provided to you was the same recording suggests to me that the exhibit had not been tampered with. Yes, well, of course, if you've burned it onto a disc after you've tampered with it, for fuck's sake, guys, you're getting desperate. Allegation 2. Mr. Dacres is alleging has been the subject of arrest and charge regarding a matter that has been summoned for the same matter. This was when P.C. Whelan came round and said, we'll get this done one way or the other. Yes, the allegation that the Chief Constable's name was on the summons. Can't consider that. That's for the Police Crime Commissioner's office. Of course. The case was reviewed by Detective Sergeant Barry, who considered the evidence to fall under blah blah blah. Similarly, I've also had sight of the MG6 form. This is a form that the police have to send to CPS and includes the rationale for the police charging decision. This is not explained in this letter at any point. Following my voluntary interview, the investigation into the offence has been sufficiently concluded to allow the full code test, don't know what that is, don't care, to be applied to the evidence. Following on from this, DC Barry then proceeded to set out the rationale as to why the case met both the evidential stage and public interest stage in order to pursue a prosecution. Which is funny because they never record these court cases. So how the fuck is it in a public interest if the public never get to fucking find out about it? Fuck me. Public interest stage in order to pursue a prosecution. But yes, I was never charged or arrested. This is the minor detail you all seem to be missing out. They do try and gloss over that one. As a result of the decision to charge you, the crime report shows you were then reported for summons, and it is confirmed in a subsequent entry the postal requisition was sent to me. They've seen a copy of the postal requisition, so that must be fucking right. In addition, the document also states that the court could issue a warrant for your arrest if you did not attend court on the specified date. It's nice of them. This is sheer gibberish. As explained in the IO's report, guidance issued by the CPS in relation to charging decisions states that the police can charge all summary-only offences, and a decision to charge is made if there is sufficient evidence to provide a realistic prospect of conviction. In this respect, the MG6 forms shows that DS Barry set out the rationale for why the case met the evidential threshold and that the alleged offence came under blah blah blah. Not explained. None of this is explained. Can't forward that evidence. Fuck me. You might get caught out lying. Right, a load of bullshit about required to attend court. So the police may institute criminal proceedings against a person by issuing a written charge, which charges a person with an offence alongside a requisition. No, you mean on the requisition, not alongside. Alongside is a totally different thing. I've already explained the MG6 form shows that DS Barry believed there was enough evidence to charge him with an offence, yes, but we've never fucking seen any of it. That's the fucking problem. Because you're a bunch of bent fucking vile fuckface lying fucking wankers, Cambridgeshire Police. To be laid to the court to issue a postal requisition, the difference being that there is no longer a requirement for the information to be laid to the court to issue a summons. So the police can just issue a summons. Doesn't have to go before the court. We feel like issuing summons today. Okay, yeah, well, we've got some bits of paper with some stuff written on them. Yeah, let's do that. Doesn't quite sound right, does it? Following on from this, as College of Policing Guidelines explains, postal charging replaces the charging process in appropriate cases. This includes instances where individuals have been voluntarily interviewed. This is when you get in the back of a marked police vehicle with uniformed officers present, so you've therefore been arrested and charged. You should have known that. You fucking idiot. Therefore, in summary, the evidence shows you had a voluntary interview as an alternative option to an arrest. Yes, well, one, as you stated in your last letter, you do not have to attend a voluntary interview. And two, the word arrest was never fucking mentioned. I haven't written anything on that bit. I guess I have. So I was being placed under arrest for failing to appear at court, which is when the police can just make up their own summons, obviously. In addition, I also note the IO sought clarification from a supervisor in the relevant department regarding the police procedure for when a warrant is issued by the court. But you just said they didn't need to lay any evidence to the court. That the police could just... Oh dear. The supervisor confirmed that paper warrants were no longer issued, and the details about the warrant are obtained from databases when the force is notified of its existence. Oh! So there wasn't a warrant, or there was a warrant, or there was a summons issued by the police but not the court, and the court didn't have a warrant. Wow. You also state you were threatened by violence by PC Whelan, kept in the cells, and that the desk sergeant at the custody suite laughed at your medical condition. I am aware that these latter issues have been dealt with in an early investigation. Yes, as I recall, you lost the recording. Lost. That was how it was dealt with. Yeah, so you couldn't comment on that. And neither can you. Also, I will not comment upon these additional issues. From my analysis of the evidence, the instruction to arrest you was issued by the magistrate's court in the form of a warrant. But there wasn't a warrant. That was on the computer system. And this information was then passed on to officers after the force was notified of its existence. Indeed, in his body camera footage, PC Whelan explained to you that he was not the person who issued the warrant. I don't remember that. Don't think he did. While I appreciate that you believe the arrest warrant itself was unlawful, it is my role to consider the conduct of the police officers. Nice one. Bit of a sidestep there. Let's forget about the warrant, the fact it didn't exist. What did I write there? Oh yes, the warrant which doesn't exist apparently. Then it's a load of psychobabble about appropriate authority, any person have a case to answer, should the CPS be involved? Well, no, the CPS aren't allowed to speak to me. Sorry. They find me terribly offensive. Are there any points we cannot consider? It took quite a few, apparently. No, they've already been covered, apparently. Therefore, in terms of the CPS, it is not within my remit to comment on the points you make in relation to them to not having a fair trial and seeking a reimbursement of the fines that were issued to you in court. In addition, I am also unable to comment on your points about the CPS informing you that they were vacating the court date, withholding and ignoring evidence, refusing to speak to you, and making a complaint to YouTube to have one of your videos censored. So that's a lot of detail, isn't it? That's like at least 4 major points. But that doesn't interest them at all. Yeah. Following on from this, you state in your appeal representations you've never actually seen the actual arrest warrant and that you instead have only seen a document that was printed off and could not be read as the writing was too small. I am aware that this issue was not in your original complaint emails and was also the subject of an earlier investigation. Right, so it's the subject of an earlier investigation, but it was not in my original complaint emails. I guess there's 2 meanings to the word original now. I missed this bit. Similarly, your point about the court statement from the staff member who sent the postal requisition not being signed was also not part of your original complaint. Ah, well, fuck it. Chuck it in the fucking bucket. We're not interested in public servants breaking the fucking law. No. Because we make up the fucking law as we go along. I can't remember how much more I outlined, actually. I think there was some on the back page. Oh, yes. Oh, yes, this is brilliant. The IO also stated there is a time limit of 6 months for prosecutions to be heard. This is in relation to the need for a prosecutor to inform a court, for example, by issuing a postal requisition within 6 months of the alleged offence, as opposed to 6 months time limit for the actual court case to take place. Yes, so they can keep you on hold for 10 fucking years if you want, as long as the postal requisition has been issued within 6 months of the interview where you were not charged or arrested with any offence, right? Fuck me, they could keep you waiting for 10 fucking years. Wait to see if you're going to go to court or not. Yep, they can do what the fuck they like. Do the words making shit up as you go along spring to mind? Oh, luckily, that wasn't part of my original complaint. Fuck it, bucket. So you see what they've done there? They've addressed it, they've sidestepped it, and then they've said it's not relevant. Similarly, your appeal point about not obtaining a warrant for the indictable offence, which was subsequently discontinued. Right, so thank you, it was subsequently discontinued. So you told me it was not being taken to court, and then you went ahead and went to court anyway. You fucking lying bastards. But luckily, is also related to your later arrest. I was not the subject of the current investigation. Oh my God. This is the best bit, the bit at the end. We are committed to providing the highest possible standard of customer service. Customer, your customers. It's a privatised limited police force. You are customers. They are a business. It is their business to get money out of you. The police get money for putting people in their cells. The prison get money for keeping people in their cells. We are aware sometimes things might go wrong. Really? I can't do anymore. Sorry. Oh.